All right. Well, good day, everyone, and welcome to PrimePay's final webinar of the year titled PrimePay's Guide to 2019, the Year in Review. Hello, everyone. My name is Steve Jackson. I'm the Senior Vice President of our Broker Concierge Partner Program here at PrimePay, and I want to welcome you to today's webinar. Before we get started today, allow me to cover some of the logistics for our webinar. Today's session is pre-recorded. And for that reason, we have muted everyone's lines. But that does not mean that we do not want to hear from you, because as you can tell, I'm actually live here right now. As we go through the content today, I am sure that you're going to have some questions that need to be addressed. And our HR advisory team is going to love to be able to provide you with those answers. To type in your question, what I'd ask you to do is to please go directly into the GoToMeeting menu bar and into the question box. You can type in your question at any time throughout the webinar. There's going to be a lot of interesting topics mentioned today. So you're going to, as you think about that question, go ahead and type it at that time, right in that GoToMeeting menu bar, all right, in that question box. We have also created a hashtag PrimePay Year in Review, and you'll see it on virtually every slide, all right? And you may also use that hashtag to make your comments or ask questions directly through Facebook or Twitter. Upon completion of the webinar, your questions will be directed to the HR advisory team for their direct response. Okay, so look for that. Now, one of the most popular questions that we receive all the time is, are you recording this? And can we have a copy of the presentation? So if you'd look in your GoToMeeting menu bar in the handout section of that menu, you're going to see a PDF of the presentation deck. That is the deck that we are using today. So please feel free to download that as you follow along. Now, in our follow-up email to you, we will also be providing a copy of the link to today's recording. So it is being recorded. Now, on another exciting note, today's webinar is also approved for one continuing education credit for those seeking SHRM and or HRCI credits. And I'm going to be providing the credit codes to you at the end of the session today. So I think that'll kind of wrap up at least some of the logistics here. As I was thinking about today's topic, each year we have the opportunity to present a year in review. And there is a word that always pops up in my mind as we think about the year in review. And that word is change. What emotions are invoked when I say that word, change, right? That word creates just a different set of emotions in all of us. When we hear it, it could bring absolute joy and exuberation, while others, right, maybe many others, it can bring anxiety and fear. It's a powerful word, right? And 2019 has had its share of change. Decisions from legislation at the federal and state levels were numerous, right? And could be found quite complicated for business owners like yourselves to manage and maintain and determine your appropriate levels of next steps with those legislative changes. This webinar, we look to capture some of the key changes and topics of 2019 so that you can better prepare for 2020, where, guess what? More change will occur. I can't say for sure that you will have feelings of joy and exuberation while participating in today's topics, but my hope is that we can reduce some of that anxiety and fear that some of you might have. Today's session, as I mentioned, is pre-recorded, and it's brought to you by our partners, Think HR. The Think HR team powers our HR advisory solution, which many of you utilize today. They deliver an integrated suite of HR knowledge, compliance tools, and training solutions supported by live experts. At the end of our webcast, I'm going to share some additional details as to our follow-up emails that we will provide to you, and also any additional resources that will be provided for those attending today. So here's what I'd like you to do. Just sit back, relax, maybe take some notes, but type in your questions, right, and enjoy today's presentation.
So I wanted to introduce our speakers to you. Today we have Kara Gavra. She is a senior legal analyst at Mammoth HR, who is our partner, and also John Dickinson. He is a senior partner at Constandy Brooks Smith and Profet. They're the law firm that's behind our Living Handbook program. I'm Rachel Sobel. I'm a content marketing specialist, and I will be just introducing and moderating today. So today we're going to hit on a number of very hot topics. They are harassment, marijuana laws, wage and hour laws, discrimination, and paid leave. These are all areas where we've had kind of a lot happen in the past year, and we're expecting more to go on in 2020. We have also talked about many of these topics in webinars this year, so if you wanted to get a full hour on any of these topics, they are available for on-demand viewing in Comply, and I recommend that you log on to that to watch the webinars on these topics. But this today will offer you a great overview from a legal perspective. So without further ado, I'm going to turn things over to John, who is going to start us off with harassment. John?
Thank you, Rachel. Hello, everyone. It's now commonly acknowledged that the phrase "Me Too" was coined by sexual assault survivor Tarana Burke in 2006. Those two words were recast in 2007 as part of an overall groundswell hashtag movement against inappropriate and illegal sexual conduct in and outside the American workplace. During the period 2017 to 2019, we've clearly seen a dramatic surge in recognition of sexual harassment and in policy making to prevent it from occurring. It's hard to believe that during the late 70s, when sexual harassment claims were first being made, courts routinely refused to find that harassment on the basis of sex was a form of sex discrimination. Not until 1980, in the Supreme Court's Vinson versus Meritor Savings Bank decision, was the legal debate finally decided. With that brief background, let's review some recent statistics and some developments. As you can see from this slide, the EEOC had a 13.6% increase in charges alleging sexual harassment during fiscal year 2018. The 19 statistics aren't out yet, but we expect to see an increase beyond that for the 19 year. What does this tell us? Well, because a charge is a precursor to a lawsuit, we expect that there will be more litigation as a result of this surge in charge activity. And of course, the FEP state agencies are also seeing an uptick in charge as well. Let's look at these statistics from this graph here. As you can see, the growth in charge activity on the basis of sexual harassment allegations increased from 17 to 18. That's that increase, and there are approximately 75,000 charges total being filed in 2018. So about 10% of those charges were of a sexual harassment nature. Let's go to the next slide. There's a big difference in the way men and women see this this area of discrimination. 17 months after the Me Too movement exploded, United States men are less convinced than they were at the start of the movement. That's kind of shocking, that sexual harassment in the workplace is a major problem. Clearly, men and women don't see eye to eye on all the issues involving sexual harassment. In the 2019 Gallup survey, it was found that while 70% of women polled believe that sexual harassment in the workplace is a major problem, only 53% of men feel the same way. Let's go to the next slide. What about the generational gap, too, that we've seen, and how men look at this topic with respect to their ages? As you can see here, this slide shows that older males, 50 years of age and older, are more apt to believe that sexual harassment is not a major problem in the workplace. That's a problem when it comes to how we train and how we're communicating with the males in the audience when we do so. We need to take that statistic into account. Let's go to the next slide if we can. Men versus women, we can see the difference in the way that how people feel about the sensitivity of it. Clearly, we see that males are feeling that there's too much sensitivity given to this topic versus men in the workplace. Monetary relief is a big issue too when it comes to these, and this is why this topic of sexual harassment has got to be taken seriously. As I stated before, the charge activity is up, but so is the monetary relief. This graph shows the millions of dollars that the EEOC is obtaining on behalf of victims in the charge processing. In other words, the EEOC engages in conciliation efforts to mediate these charges, and as you can see, there's been a growth in 2018 of between $46 million to $56 million was collected by the EEOC in the resolution of these charges of sexual harassment. This next slide shows us that we are seeing, as a result, lawmakers entering the picture and trying to take activity that will curb sexual harassment problem. So we see here that while there is no federal law requiring sexual harassment training, some of the cases have been making references to the duty to train in court decisions. So state law has taken over, and we see many, many states now requiring that sexual harassment training be part of orientation and part of the history of employment when people enter the workforce. This slide also reflects that in Illinois, New York, and Connecticut, just in 2019, either beefed up or created a training requirement in their states. And it's interesting that every one of these laws that have been passed, they vary in the timing that the training is required, the amount of training that's required, the format, whether it be interactive, can it be by video or online video, and so forth. So we have to be very careful when we go to interpret these statutes. This is a slide that shows the states that now require sexual harassment training. There are 7 states that mandate some form of sexual harassment training for private employers. And this training is geared toward ensuring that employees understand the law of sexual harassment, to avoid or minimize legal liability, to avoid morale problems. There's a great turnover when harassment takes place in the workplace, to avoid negligent publicity that an employer may incur as a result of an harassment allegation, and to protect the potential availability of affirmative defenses in litigation. We're going to see more and more of this. The slide also reflects the date that the training is to begin in those states that we see here on this slide. Interestingly enough, Maine was the first state in the nation to pass this law requiring sexual harassment training back in 1991. And my final slide I'd like to go over is this one here. Workplace transparency legislation. The Me Too movement has clearly turned a spotlight on confidential settlement agreements and how they might prevent a public discourse on the problems associated with sexual harassment and prevent victims from speaking out. This slide labels recent legislation to ensure that employers cannot hide claims of sexual harassment through confidentiality provisions in settlement agreements, general confidentiality policies, and agreements on arbitration. The very first part of that slide is the Tax Cuts and Jobs Act, often referred to as the Weinstein Act. In that situation, the president signed legislation under the Job Tax Act that basically stated that if you're going to have a settlement agreement involving claims of harassment or assault, if you have a non-disclosure provision in it, the employer cannot take a tax deduction for the expense of that settlement. But every one of these states associated on this slide have legislation to make transparency the subject of sexual harassment in the workplace. Rachel, I'll turn it back over to you.
Sure, thanks, John. Before you log off, I know you had some tips for how people could stay compliant with sexual harassment laws. Can you go over those with us real quick?
Yes, let me just say this, that oftentimes we get the question, well, if we have a sexual harassment statute, how do we make sure that we're going to follow that statute and be in compliance? We always recommend that the first thing you do is to go to the source, either the website of the local government or the state that you're in, because their websites will have specific information related to the legislation that they have. You want to make sure that you then calendar the dates on when certain things have to be done. When do you have to have your training by? Is it within so many months of somebody beginning employment? Is it a certain specific date? Whatever the statute or the regulation requires. Then we're going to want to make sure that we select somebody who is very qualified. The person who trains on the subject of sexual harassment should be an expert on the topic, particularly in the interactive process during that training, so that questions can be answered in a great positive way. Then we need to prepare our materials to make sure that they're compliant with what the requirements are in a statute or regulation. Oftentimes, the legislation will have specific things that must be included in the training materials, and we must make sure that we are compliant with that. We want to always document all training that we perform. It should be documented in the file. There should be acknowledgments signed off by the participants. And then finally, for those people who miss the training because of some emergency or their absence for some reason, we want to make sure that we go back, circle back, and train those individuals so they don't slip through the crack. Those 6 steps will help us stay compliant with these laws as they develop.
Thanks, John. Before we move on to the next section on marijuana, I just wanted to remind you that all Think HR customers have the option to add our workplace harassment prevention program. That provides both the actual courses that employees and supervisors take, and they are specific to the states that have specific requirements. I know we saw in the last the map that there are only a handful of states that have these rules, but those states are the biggest states, and that comprises a very large percentage of employees in the United States that need to be trained. And so by using the Workplace Harassment Prevention Training Program, you can get compliant, state-specific training. It also comes with documentation, and it's interactive, provides a certificate of completion. You can track who's taking things when. So if you are interested in learning more about this, if you want to type in the Q&A box right now, workplace harassment prevention, or even just WHP, we will get back to you with more information on how you can upgrade your Think HR subscription to include this. So with that, I'm going to turn things over to Kara, who's going to talk to us a bit about the proliferation of marijuana laws in the United States and what you need to know to be compliant. Kara?
All right. Thank you so much. Yeah, we're going to talk about marijuana for a few minutes here. It's a hot topic right now, and it's something employers need to understand better than most of them do at the moment. Let's talk really quickly about federal regulation. Marijuana is still illegal at the federal level. It's still a Schedule I substance. It's not okay. It is illegal under federal law. Even medical marijuana is not technically legal under federal law, though the feds have said that they're going to look the other way on that one. What this means is that the ADA, the Americans with Disabilities Act, does not protect medical marijuana use, and there's no federal protection for recreational use. However, a lot of states have their own law that looks a little bit like the ADA and prevents discrimination. And those state laws may or may not cover medical use. So that's where things get a little bit complicated. Let's take a look at the sort of patchwork of state laws we've got going on right now. Medical marijuana is legal in more than 2/3 of states fairly broadly. meaning in about 2/3 of states, you could go out and get a prescription for medical marijuana and like smoke a joint on your front porch. There are other states that allow medical marijuana, but in very, very limited capacities, like only for epileptic seizure or possibly only CBD oil or something with an incredibly low amount of THC in it. So those exist as well. And then, of course, we've got the states who are like, everything goes. It's good medically. It's good recreationally. You can just, I think I've got 3 dispensaries within about, 2 miles of my house. It's kind of crazy. So we've definitely got a patchwork going on. And we have an even, I'd say, more complicated patchwork of laws related to employment. What employers want to hear, and what is still totally true, is that regardless of what's going on with your state law, you never have to let an employee be high at work. Okay? You don't have to let them smoke marijuana on their break. You don't have to let them come to work impaired or be impaired during their shift. So it's important to keep that in mind. None of these anti-discrimination laws that are passing or will pass in the future require that you let an employee be high while they're at their desk or while they're serving customers. What we have seen in the last year are some both statutes and case law going toward anti-discrimination. So Illinois, Nevada, Oklahoma, and DC, all in just 2019, passed some kind of anti-discrimination law with respect to medical use. We also saw some anti-discrimination laws related to recreational use in Nevada and Illinois. However, both of those are honestly pretty weak. So just because you see that on the screen doesn't mean you should panic and think that all recreational use is protected in those 2 states. It is heavily protected in Maine, interesting enough. But Nevada and Illinois, what they've actually got going on right now are some limitations on pre-employment testing. That's almost the extent of the law. And Illinois actually just amended the law that they originally passed to make it more friendly to employers. So basically, as long as you have a reasonable workplace policy that's actually in place, that you're using in a reasonable fashion, you can still be actually pretty discriminatory toward recreational use in Illinois. New York City is being very specific, however, about testing before employment. Their law goes into effect May 1st, 2020. Basically, there's a lot going on out there that we're needing to keep track of. Here's just sort of a smorgasbord of what could be happening. Your state law might permit both medicinal and recreational use. It might prohibit pre-employment drug testing, or it might say, no pre-employment drug testing, but you can test after they're employed. But then maybe the state requires that they be allowed to submit a second test result. That seems to be a little bit popular right now. My theory is that the states want marijuana users, to be able to quit prior to getting a job. Because it generally gets out of your system, depending on how frequently you use, within a month. That's like at the long end. So states seem to be writing these laws in a way that would allow someone who does use but wants to get employment, where any use is not allowed, even recreational outside of the office use. It's allowing them to sort of get clean for that job. So that's sort of an interesting twist that we're seeing right now. And of course, you need to think about whether your state requires in any fashion that you accommodate medical use. Because like I said, the ADA, the federal law, is not going to require accommodation for medical marijuana, but state laws might. Unfortunately, a lot of state laws related to marijuana aren't clear about that. So there will be a law that says that marijuana is acceptable for medical use, but it won't say anything about employment. Or there will be a law that passes recreational use that says employers don't have to, accommodate recreational use, but it doesn't say anything about medical. So lots of the laws that are coming to us right now are actually based on case law. and case law can actually be a little bit hard to track, and as you may be familiar, is pretty slow going. So in the meantime, what can employers do to stay compliant? Well, as much as possible, you want to be paying attention to what's going on at the state level for you, and even at the city level. Most smaller cities aren't getting into this, but big cities like New York City, possibly, Seattle, Los Angeles, those are cities I can see getting into the mix on this. You want to keep track of what they're up to. You do have the option, of course, of not testing at all for THC. That would sort of take that bit of compliance nuisance out of your hair. just don't check for it. You'd probably be surprised how many people turned up with positive results if you decided to go out and randomly test your workforce today. I definitely don't recommend that. That may not even be legal in your state. I just want to make the point that in many cases, recreational use is not going to impact your workers or how they perform. So it's possible that you could actually save yourself a lot of money and a lot of heartache just by not testing for THC. There are, of course, situations like if you've got DOT licensing to think about where that's still going to be required. And the state laws don't trump federal laws about, whether you need to test for people who are, driving. If you do want to continue testing, that's perfectly fine. However, just be prepared to have conversations about accommodations for medical use. Basically, if your state allows medical marijuana use, you'll need to dig into whether there are any employment protections whatsoever. If someone tells you as a result of a positive test that they are using because of a medical issue. It's basically most of those states will require something that looks like the federal interactive process under the ADA. Even though the ADA doesn't apply, we do need to consider state law. Okay, let's talk about wage and hour, which is thankfully a much more cut and dry, straightforward, black and white topic. It appeals to a lot of employers for that reason. First, today we're going to talk about the new minimum salary for employees who are exempt as white-collar workers. And then we're also going to talk about pay equity. So first up, the white-collar exemptions. What we're talking about here is the new rule that's going into effect on January 1st, 2020, that says that employees who are exempt under particular white-collar exemptions need to be paid at least $684 a week. You may recall that we almost got a new rule at the end of 2016 that would have made that $913 a week. And employers were understandably sort of losing their minds because they were going to have to reclassify millions of employees, either reclassify or give raises to millions of employees, many millions. I personally gave over 50 webinars on that topic. So it was a really big deal. Sort of interestingly, this time around, at $684 a week, I have seen almost no panic at all. That might be different for you. I'm not saying there's no panic out there, but for the most part, where there was hysteria about the 913, 684 seems to be going over pretty well, which implies to me that most employers out there, when they've got people classified as exempt, they're already paying them $35,000 a year or pretty darn close to it. So that's good news. We're seeing fewer frantic employers. Like the rule that was proposed in 2016, up to 10% of that income can be through non-discretionary bonuses, commissions, or incentive pay. So about $3,500 a year. Not half of it, not all of it. When we're talking about our administrative, professional, executive, and computer employees, they all have this base of $684 per week. Only 10% can come from those non-discretionary bonuses. The duties tests haven't changed. If you don't know what the duties tests are, I would recommend that now is a good time to go learn about them, since you might be doing a little bit of auditing of your workforce. These tests say that employees have to do certain things in order to qualify for their exemption. So the executive exemption is one that catches a lot of employers off guard. It says that the employee's primary duty must be management, and that they need to manage 2 or more full-time or equivalent employees. So lots of times we work with micro employers who have a manager who only manages maybe 3 part-time employees. That person is not going to qualify for the executive exemption. It's possible they'll qualify for the administrative exemption, but they won't qualify for the one the employer may have been relying on because they never really dug into the duties test. They just heard that you could make managers exempt. So if you're doing a little bit of auditing in there, I would recommend that you consider whether the employees you have labeled as exempt are actually doing the duties that you need them to do. It seems I have skipped ahead a few slides and lost control of my mouse. All right. So once you've determined that your people are in the right exemptions, also think about whether you might be taking any deductions that you're not supposed to take. This also catches employers off guard, particularly those who don't necessarily know about the duties test. They might not know about the exemption rules. So for instance, if you've got someone who is an exempt employee, let's say they're properly classified as exempt, if they come in one day, they usually have an 8-hour shift, and they become violently ill after the first 30 minutes and go home, they need to be paid for the entire day, not just 30 minutes. That's sort of like the essence of being an exempt employee, is you're paid the same amount every week, regardless of the quantity or quality or number of hours you have put in. But the trade-off is that if you want that person to work 60 hours a week, you can do that without paying them overtime. So this is probably very old hat to many of you, but it's one of the mistakes we run into a lot, so I just wanted to point that out. All right, now let's take a look at pay equity. This is a hot topic all across the country right now. It might surprise you to learn that we have a federal equal pay law that has actually been around since 1963, a very long time. The issue with the federal law is that it requires equal pay for equal work, and equal has been construed very, very literally over the years. So it has been very hard for plaintiffs to bring cases and to win cases, because even the slightest deviation between 2 workers in what they do could blow up a whole case. Because the federal law has been so narrow and so hard to apply, states have gotten in on the action. They've started passing their own pay equity laws. The ones mentioned on this slide are just from 2019. 2016 through 2018 saw a lot of activity, a lot of really big pay equity laws passed, particularly like on the West Coast and the East Coast. The coasts are sort of the ones who are always in the mix on employment law and sort of ahead of the curve. But just in 2019, New York, Illinois, Washington, Maine, and Alabama either created a new law or expanded the law they had in place already. We've also seen a bunch more salary history bans put into place. So those are kind of low-hanging fruit. There's something easy that employers can do, or excuse me, not employers, but states can do to get employers on the right track. The idea being that when you ask for somebody's salary history, that has been impacted perhaps their entire career by sex discrimination. Not always. I'm not saying that always happens, but you know, if a woman is paid $5,000 less than her male colleague when she's new out of college, that salary history will follow her around her entire career. In many of the states with pay equity laws, you're also not allowed to explain a difference in pay only based on salary history. So even if you could technically ask about salary history, it could get you in trouble in a number of these states that have passed more serious pay equity laws. So what can we do about this? What should we be doing about this as employers? Well, we need to know our state laws. Some are much more intense than others. California, Oregon, Massachusetts, they all have pretty serious state laws. We also need to review our employment applications and check for salary history questions. This is not illegal in all states. Salary history inquiry is illegal in maybe 10 states right now and a handful of cities. But just to sort of get ahead of any law that may be coming for you soon, I would recommend taking those off applications. I personally just think it's best practice not to ask. I think you should be paying people based on their experience and based on the market, not based on what they made before. That's not necessarily good information. We need to train our managers, particularly, of course, those who are either hiring or those who have control over pay issues like raises, basically. We need to think about our pay ranges for positions. So at both the federal and like pretty much every single state law says that you can have differences in pay based on merit and seniority so long as it's based on a system. So within our pay range, we need to have a system. Why is someone at the bottom versus the top? Can we explain it? We need to be able to explain our thought process if we're challenged in the courts or challenged by a state agency. That's probably where it'll usually start. To get there, we need to audit our internal compensation practices and adjust as needed. If you're in a state that already has one of these gnarly pay equity laws, you need to do this now because every day you're behind the ball is another day of back wages that people could get if they sued you and won. So basically every day you're potentially losing money that you don't deal with this. If you're in a state that sort of doesn't have a law, maybe it's just relying on the federal law, or the state law looks like the federal law, I'd still recommend you do this. Get ahead of the game. And that way, when a big law comes to your state, you're ready for it. You're like, I feel confident, I'm not worried. All right. Pay equity is a hard one. It may require outside help, but do be aware that it's out there and it's something to keep your eye on. All right, the last thing I wanted to talk about today is discrimination. So there are basically two things employers get sued about. The first is discrimination in the workplace. The second is wage and hour. Generally misclassification leading to unpaid overtime. Discrimination, though, is of course bigger, it's grayer, it's harder to pin down. What we're going to talk about right now are the LGBTQ cases that are before the Supreme Court of the United States, as well as the expansion of protected classes. So SCOTUS is Supreme Court of the United States. I might use that abbreviation one more time. They heard 3 cases in October of this year related to sexual orientation and gender identity and discrimination in the workplace related to those characteristics. We are waiting on those rulings to come out. I think it could easily be like June before we hear. This has become an issue because we've got Title VII. You're all probably pretty familiar with Title VII. It protects certain classes of people by race, color, sex, and national origin or religion. We've got a couple other federal laws at play too, like the Age Discrimination and Employment Act that says you can't discriminate against people over 40. We've got the Americans with Disabilities Act, Pregnancy Disability Act, and the Genetic Information Non-Discrimination Act. So we've got a bunch of stuff protected at the federal level. But sex, we've been a little confused about. What does that mean? Does it include sexual orientation and gender identity? The Equal Employment Opportunity Commission gets to enforce Title VII, and their take on it for many years now has been that sex does include those things. It does include orientation, and it does include identity. However, that's not clearly written into federal law. So there have been employers out there who aren't following it that way. They're following sort of the strict determination as like, this is biological sex only, and they've been discriminating. And they believe that they're entitled to do that. The EEOC believes they're not. And so now we're letting the Supreme Court decide. Given the current makeup of the court, there's a very decent chance they're going to decide that sex has a very narrow meaning, and it's only about, biologic male-female sex. However, in many ways that barely matters because most states have at least gotten in the game on sexual orientation, and a number have gotten in the game on gender identity. So just like there are state disability laws that sort of pile on to the federal ADA, there are also state human laws that pile on to Title VII and those other laws I mentioned. So even if it appears that you could discriminate based on sexual orientation at the federal level, there's a very good chance that your state says that you can't do that. Our next slide is about EEOC enforcement and how it has how it looks in 2018. As you can see, sex is a pretty big category for these filings. I would wager that most of those claims are based on just basic like male-female differences in treatment, not sexual orientation or gender identity. So even if those are ruled out at the federal level, I still think you're going to see almost as many sex discrimination claims. And of course, retaliation is also huge because people complain about these things in the workplace, and instead of sort of responding in a positive, nurturing manner, the employer fires them or demotes them or moves them to a different department, reacts badly, and so then we pile a retaliation claim on top of the original claim. But like I was saying, it doesn't necessarily matter what the federal government thinks or what the EEOC thinks, because states and cities are in this. And they have been for many years. Marital status has long been protected at the more local level. Not everywhere, but lots of places. Credit history, that might surprise you, but a number of places say you shouldn't be using credit history or credit score. Same with arrest record or off-duty lawful activities. So basically, drinking off the job, smoking off the job. Those are protected in certain states and cities. A new one in 2019 that was passed by both New York and California is an interpretation of race to include traits associated with race, and they specifically wanted to call out hairstyles. So if you're in California or New York and you've got a personal appearance policy that says anything to the effect of no cornrows, no braids, no afros, you'd want to be taking that out of your policy. Honestly, if you've got that in a policy anywhere in the country, it would be my preference that you took that out, get ahead of the game, and sort of do the right thing there. But at least in California and New York, you do need to remove such policies. All right, our last slide here, how to be compliant. So I talked a lot. City and state EEO laws, know what they are. Audit your hiring and employment practices. So like I just said, if you've got a policy against afros in your personal appearance policy, you want to take that out. If you are checking everybody's credit score and their arrest records, you should check and see if state laws allow for that. And even outside of what state law says, you might want to consider if that's really information you need to have that's important for you. And then finally, you want to keep up with what's changing. So like I said, that SCOTUS decision about the meaning of sex is actually not relevant to more than half of employers, because more than half of employers are already subject to state laws on the issues. But you definitely want to keep up with state laws and local laws because those will continue to impact you and what you can do and what you need to respond to when you get a discrimination claim as an employer. All right, I'm going to turn it over to Rachel now to talk about our awesome Living Handbook feature.
Thanks, Kara. That's really helpful information. I hope everybody else is getting as much out of this as I am. Before we turn things back over to John, I just wanted to give a little plug for our Living Handbook. Your ThinkHR subscription automatically includes access to our handbook builder. That includes automatic updates to help you keep up with the waves of legislation. So if anything changes in your state, we will update the policies for you, and you'll get a notification to go in and accept those. And that way your handbook can always be up to date. In addition, we do have some kind of additional features that you can add to your subscription, including the option to do a multi-state handbook that has every state in which you have employees in one handbook, click of a button Spanish translation, and e-signature options that help you track the receipt of the handbook are all available to our subscribers with Living Handbook Plus. If you're interested in getting more information about Living Handbook Plus to get these additional features, if they would be helpful for you, you can just type in the Q&A box right now, handbook, and we will send you more information on that. So with that, I'm going to turn things over to John, who's going to talk to us a little bit about leave, which, it sounds like it's a pretty typical thing that you've been dealing with forever, but there have been lots of state-by-state augmentations to leave laws, both paid and unpaid, that really have the potential to make it even more complicated to administer time off. So, John, if you can explain, that would be wonderful. Thanks.
Thank you, Rachel. And I have to say before I get started, in case anybody wonders if that's me on that surfboard, it's really not on the surfboard having to do with handbooks. It's not my picture. Tara's given us a lot of information on developments that we have to stay abreast of. I want to cover one last topic, and that has to do with what's going on in the area of leave and paid leave. Since 1993, we've all had to, those of us of any large size employer, had to worry about compliance with the FMLA and making sure that we provide employees family medical leave under the federal law. And of course, we've had to worry about accommodation issues and leave being a form of accommodation under the ADA. But the Me Too movement has clearly resulted in activity from state and local governments in passing legislation to require different forms of paid leave benefits for various kinds of activities. For example, we are seeing laws that now require that we provide paid leave at the state or local level for domestic violence, for sexual assault, for stalking, to even obtain medical records, to address situations experienced during pregnancy, for bonding with newborns, to attend school activities, to donate blood or organs, or to breastfeed, or for any reason. At least under Nevada law, the laws requires that an employee be given leave for any reason at the employee's choice. So there's a labyrinth of these states that have passed this legislation. It is very complicated. The amounts of leave that will be required, the interplay with the FMLA, and these issues will be taxing us for some time. 2019 saw a surge in activity in the passage of paid leave enactments. Interestingly, we think it's being driven not only by the Me Too movement, but clearly by the composition of the American workforce. We have more single mothers working. We have dual earner households. This is trending upwards. When we have more and more women in the workplace, the leave requirements are also being more complicated as a result of that. Unlike so many other industrialized countries, the United States does not have a national paid leave mandate. Congress has been faced from time to time with potential legislation to make FMLA paid, but nothing has happened yet in that regard, and we don't see anything happening very soon on a national level when it comes to paid leave. This slide does reflect that, at least in New Jersey, for example, we saw legislation in 2019 expanding that state's laws to broaden coverage of qualifying reasons for leave. Massachusetts, too, has had new regulations relating to employer contributions to paid leave benefits. And Nevada, which I mentioned earlier, now has expansion of its paid leave program. So we're going to see more and more of this, we believe, as a result of the Me Too movement. This particular slide reflects that there are 8 states in the union that have paid family or parental leave laws, and they're in blue and teal checkerboard on this slide. 13 states with provisions for unpaid leave have been passed for family and parental leave reasons. They're in the green and the teal checkerboard. And there is a Think HR white paper that you can have access to with more details on these state laws. So from either a paid or unpaid leave perspective, we can see great state activity when it comes to this, which is going to be very, very complicated when we try to comply with that and make it dovetail into family medical leave requirements. In addition to paid family and medical leave, then there are the group of laws that we're going to label as paid sick leave laws. And you can see from this chart that the family leave chart is large, but it looks pretty tame when you take a look at this paid sick leave chart. This one, you really need to go to the white paper that Think HR has to look at your location and see what might apply to your business. What's important to remember is that there are no overriding federal laws on this topic. Every state has different provisions. It isn't just family or parental or sick leave. It could be a combination of qualification factors for this type of leave in the state or location that you operate within. There are other types of time off, some paid and some unpaid, for emergency services, time off, crime victims, and so forth. So we're going to need to be very careful in the location within which you operate to go and find out all you can with respect to the requirements in the particular state in which you operate. Also, municipalities, local governments are getting involved in the activity of requiring paid leave. Look at these. We break it down by state and locality within the state. And as you can see, we have a lot of activity out on the West Coast. And as Kara said before, oftentimes things start on the West Coast and they have a tendency to move eastward. We're going to see this, I think, as a result of developments in this area. State legislatures are feeling as though that employees need to be protected when they need to be away from work, particularly if it's for childbearing purposes or bonding and things like that. So we're going to need to be on the outlook with respect to not only state, but municipal activity as well.
All right. Well, I do appreciate very much, John, your comments here on the municipal paid sick leave. Thank you so much for that information. I do want to thank the Think HR team today for providing this valuable content. This year in review, wow, there was a ton of information here in regard to workplace harassment. I see a lot of you in your question box, asking for additional information as it relates to the workplace harassment and certainly how that applies, right? Not just from federal, but state basis as well. We dove into kind of a lot more in this legalization of marijuana and what does this mean, this year, but how is this thing going to progress into 2020 and then certainly into the new overtime rules with wage and hour. We talked about specific various discrimination issues and Kara had really explained that. And then certainly and lastly here on the paid leaves of absence. It's becoming a more and more a critical area for employers to comply. And so I want to thank Rachel, Kara, John for providing this great content here today. That will actually take care of our learning content here for today. But I do want to move here and make sure that for those of you who are seeking 1 hour of credit, all right, I have posted here now on the screen the credit codes for HRCI, which is 503873, and then also for SHRM, and that's 19-Q, as in quiet, RG, 7 and W. All right, so just write those down if you are in need of those credits. All right. So again, I want to thank the Think HR team for providing us with your personal 2019 year in review. And many of you have asked specific questions related to these topics, and those will be forwarded to the HR advisory team, and then they will be answered directly. So look for that information here after the webinar here today. A service that would enable you to learn more about the key topics discussed today can be found by utilizing PrimePay's HR advisory services. And that is actually powered by ThinkHR, so what they were speaking of here today. Our $4 per month version delivers on comprehensive web content, employee handbook builders, 5 employee training courses, and other tools and resources to help your business. By upgrading to HR Advisory Advanced for only $39 per month, you receive not just federal level, but state level employee handbook builders, increase the number of learning courses for your employees and managers from only 5 to over 200, and you enable a certified HR live team who can provide written responses to your complex issues. And so please just visit the links on the screen to learn more about those specific solutions. So as a follow-up to today's webinar, I want you to look out for the following. There's going to be a link to the recording here today. We will provide you a copy of that slide deck. So if you are unable to download it here today during the webinar in that GoToMeeting menu, we will get that to you. And we also ask for your feedback. So a survey will be sent out to you. We'd love to hear from you in regard to not only the content provided today, but also ideas for future topics as we go into 2020. I can't thank you enough for participating in our webinar today. We're grateful that many of you have selected PrimePay for your payroll, compliance, and other business service needs. I want to thank you for the opportunity that we have been able to serve you in 2019, and we welcome the opportunity to go the extra degree with you in 2020. So this will conclude our webinar series in 2019. Please visit our events page on primepay.com to get more details of our upcoming webinar series schedule in 2020. I want to wish you a very happy holidays and a happy new year, and we look forward to seeing you next time.